welcome to Crime and Court. My name is Heather, and this is an update in the Delphi case. We are, of course, talking about Indiana versus Richard Allen, and we are seeking justice for Abby and Libby, the girls who Richard Allen is accused of committing a double homicide against. And in this episode, as you can see, we're going to talk about Gull denying key evidence for the defense at trial, which I believe now gives Richard Allen absolutely no chance of winning any kind of, acquittal during this case because she has basically handicapped them. She has cut them off at the knees and I don't like it. I've been very vocal about Judge Gull from the beginning. I think that she should no longer be a judge by the way that she has shown herself. But here we are. This is where we're at. The Supreme Court of Indiana, for some reason, decided let's keep her on twice. And unfortunately, I think that was a huge mistake the first time when they didn't get rid of her from this case or boot her from this case. And she's obviously not seeking justice. She's seeking hiding evidence and hiding the truth, in my opinion. Otherwise, why would she be trying so hard to handicap the defense? So we're gonna watch a little clip from Court TV first up. This is gonna be a short update. We're going to go through the order that Judge Gull just gave out, basically handicapping the defense, and then we're going to go over the motion in limine and how it relates to that. That was the state's motion in limine. We've already gone through it on this channel, but it's been a while since it came out, so we'll look at it again. So that's what I have planned for us. It's going to be really quick. I do want to play a little bit of this Court TV clip when this was breaking news yesterday, September 4th. I was at an infusion for my health, so I was not able to stay up to date. So sorry, giving it to you a day late, but that's okay.
Following some new developments out of Indiana, the Delphi murder case, Indiana judge, Judge Gull, has ruled that Richard Allen cannot use a third-party culprit defense strategy at his upcoming trial. This was under contention. The defense wanted to bring in these other theories.
Yeah, Odinism being one of them. Allen is charged with 2 counts of murder for the deaths of Libby German and Abigail Williams. Their bodies were found on February 14th of 2017. And we have someone here who can discuss that a lot more.
Yes, our senior producer, Barbara McDonald, she knows this case quite well and has known it from the beginning. Let's start with this latest ruling from Judge Gull, which seems to sort of fall in place with other rulings she has made. Defense pretty much striking out across the board when it comes to Judge Gull.
That's right. And basically there was...
I want to point that out. Like, regular media is pointing out that Judge Gull often ruled against the defense. They notice it. If mainstream media is pointing this out, then there is not only an appearance of her bias, but it's obviously apparent. I mean, it's there because mainstream media doesn't report on things like that in most cases. They try to stay pretty, they try to stay away from attacking government officials whenever they can.
There's a 3-day hearing in July and the first part of August that went over this and gave the defense an opportunity to come to court and provide evidence that there was actually admissible evidence related to these third-party culprits that they wanted to point at. And the judge said after that hearing that she was not satisfied that they had done that they had not presented anything that was admissible in court showing that these people were at the scene or were not where they were supposed to be at the time. And so the judge is saying, no, you're not going to be able to bring any of this in. But the state's motion in limine was asking for a whole lot more than just limiting this third-party defense.
Yes, and we will read it again and see all the different things that the state wanted to cut the defense off at their knees and were quite successful at doing.
So some of the other things that the judge has said is not going to be allowed is any reference to even the investigator who looked into the Odinism theory. You know, that was a route that investigators had followed in the early days of the investigation.
So the three investigators, Todd Click, Greg Ferenczi, who is no longer with us, he was um, basically like lynched. Uh, there was he came out of his office building and was shots fired, and he's no longer with us. Was it related to this case? I could not find a connection, but that doesn't mean that there isn't one. Um, it's just very odd. So Greg Ferenczi, Todd Click, and Kevin Murphy are three investigators that all were still leading down this Odinist path for investigating this crime when they went to Unified Command. Unified Command told them, oh no, this is nothing, just ignore it, and this is not the line that we want to go. But these three officers decided to continue down that route because they honestly felt that that was where the evidence was taking them. And now the defense can't even bring those investigators up in trial.
They said they didn't find anything that led them to believe that that was actually what was involved here, and so they stopped pursuing it. But those materials are what the defense has seized on, and they're not even allowed to mention the detective who looked into this and wrote that initial report about Odinism. His name is Todd Click. He is now retired, and his name isn't going to come in either. There's also not going to be any reference to the geofencing data, which the defense.
This is a big problem. So it's a big problem that other potential suspects can't even come in at trial. People who were investigated and their interviews may have just magically been recorded over. They're very damaging. I'm sure interviews were recorded over. There's a lot of suspicious activity that leads you to believe that the investigation was going in a totally different path in the beginning, and then Richard Allen just came from out of nowhere, and that's why we need to know what that connection is. How did he get here? And I don't think the state has that information. I don't think that they can present that at trial, but I don't know for sure. I'll, if he is the guy, fine. But from what I've seen now, I don't see any connection. So that's a big concern of mine going into this trial is that there's so many other people it could be, yet here we are with this guy who we're all scratching our heads going, how did we get here? How do we get to Richard Allen? Same in the Idaho 4 case. It's just lack of transparency in investigations, and they need to be able to show us how they got from A to Z. They need the path in between. Anyways, let's continue.
Has indicated in filings shows that there were other phones walking around the crime scene during the time that the girls were missing and their bodies hadn't yet been discovered. And so the judge is saying that also is not going to come into this trial. The other thing that I think is rather interesting is the state asked to prohibit any reference, and this is a quote from his filing, from Nick McClelland's filing, any reference to any prior bad acts or acts of any witnesses that plan to testify. And so it's going to be really interesting. There are obviously a lot of people who follow this case who think that this judge is biased against the defense and the defendant, Richard Allen, who you see there on your screen. He has been subjected to some very harsh treatment during his incarceration after his arrest. He is now out of the maximum security prison system and is in a county jail awaiting trial, which is supposed to happen next month. But Julia, I've heard you talk about this quite a bit, that these motions and these early decisions set everything up for the tone of the trial.
They sure do. All of these motions leading up until now, as she's in her words, it sets the tone for the trial by not being able to bring in any of this third party stuff or the geofence data proving that the state's timeline is flawed, if anything, that's what they're proving, then it's totally cutting them off at the knees by not allowing them to defend themselves. It's ridiculous and it's um, completely, what's the word I'm looking for? Unwarranted. There's no reason why they shouldn't be able to bring in this stuff. I feel like through with all of the Frank's hearing motion or the Frank's motions and everything that they put forth in those documents alone, I would have my question about, the investigation and whether this onus thing had some legs to it. And I would if I was the judge, I would let that in because it's obviously an appealable issue by not letting them defend themselves. So, but the problem is he's going to get found guilty and then he has to appeal. And when you're guilty, it's almost impossible to ever win an appeal or to get exonerated through the appeals process. The system is so against defendants, especially once you're convicted, you have very little recourse. All right, so let's move on to the motion in limine from the state of Indiana. So this is, wow, this is even longer, further in time than I thought. So April 29th, 2024 is when they filed this motion in limine, which basically means we want to exclude all of these things, judge, and here's why. So we're going to read through this and then we'll read through her order. So it took so long because all the shenanigans that Judge Gull likes to have in her courtroom. And then we had to have the hearing that the woman, the panelist, was talking about on Court TV, that they had a hearing where Judge Gull was presented some of these things about the third party culprit, and she decided that there was no basis for it, even though we've all read the Franks memo, and I think there's basis. We all think there's basis, but whatever. Okay. So now, um, anyway, so they've had their hearing since, and now we have the order. That's, I believe, why it's taken so long is because they had to have that hearing. All right, so this is the motion in limine. We're going to reread it because it's been so long. So now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully request that the court enter an order requiring the defendant or his counsels to refrain from mentioning in the presence of the jury during voir dire, opening argument, presentation of evidence, and closing argument. So at any time that they have any interaction with jurors, any and all references to the following, either directly or indirectly. So we want to prevent the defense from talking about any of these topics. Number one, any comment about counsel for the state that constitutes a personal attack on the attorney for the state or comments on the role of the state attorney. Basically, don't be mean to the prosecutor, Nick McClelland. That's what he's saying. No personal attacks on me, please. Number two, any comment which constitutes the personal opinion of defense counsel about any evidence, witness, outcome, or penalty. For instance, defense counsel cannot vouch for the truthfulness or competency of any of the state's witnesses, including police officers or any of his own witnesses. Why would he? These are rules of professional conduct. So why would the defense even need to be told these rules of professional conduct, Mr. McClelland? Number three, any innuendo or inference that is not supported by admissible evidence. Attorney cannot assert unsubstantiated allegations on collateral matters. Attorney may not comment or allude to inadmissible evidence during trial. I think they know that. Being lawyers and all, I would think that they know that. All right, number 4, any attempt to indoctrinate the jury during the voir dire by exposing the jury to substantive issues in the case. And I want to point out that there are the very same things that the state is trying to prevent the defense from talking about at all during trial or voir dire or any of it are in the jury questions. They talk about the third party witnesses, they ask specific names. Do you know this person? They give you the witness list and say, are these people, do you have any relation? Do you know these names? You get asked that in voir dire. So if these people are witnesses or whatever. So, and I think like there might have even been questions about Odinism on the jury form. I can't remember now, but anyways. All right, so an attempt during the voir dire to have any jury prejudge the credibility of a witness, any hypothetical questions that includes facts that are not evidence or questions that are not helpful. Okay, well, questions that aren't helpful. Well, that goes for the prosecutor too, no? Should he also follow these rules? I would hope. Any attempt to introduce evidence of third-party motive that is not relevant and/or the probative value is outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury in violation of Rule 401. Before any such evidence may be permitted, the defense must show some connection between third party and the crime. Further, it must be a direct connection based on admissible evidence and not founded in hearsay, speculation, rumors, conjecture, or theory. These are, it's part of the investigation. So I would say that it's none of those. It's evidence, but okay. Um, the state requests such order in limine to include but not be limited to the following: Odinism, cult or ritualistic KI double Ling, Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Klein, Jerry Klein, and Ron Logan. So these other three are not connected with Odinism necessarily, but Keegan and Jerry. Keegan is the younger gentleman, and Jerry is the father who I think Keegan confessed, or at least confessed that his dad had something to do with it. I'm not really sure what the whole connection is, but they apparently have been ruled out. I don't know how or when, but not really. And then Ron Logan, who was the owner of the land in which the girls were found, or on which the girls were found. So he owned the land. And his alibi was he lied about his alibi, about his whereabouts. And geofencing proves that he was lying. All right, so number 8, any reference to an investigation conducted by Todd Click, along with any reports or investigative materials from Todd Click that is not relevant or is used for the purpose of confusing the issues or has the potential to mislead the jury in violation of Rule 401. Burden is on the opponent to show why it is relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. Evidence may be excluded if it confuses the issues. Any reference to geofencing and or wait, how just because it confuses the issues. I could see Nick saying, "Oh, well, it's just confusing. So the geofencing is confusing. Let's not bring that in." Or the Todd Click report is too confusing. Let's not confuse the jurors. Really? Calling them stupid. All right, so any reference to geofencing and or any testimony from Kevin Horan about geofencing or the findings from any geofence search that is not relevant or is for the purpose of confusing the issues or has the potential to mislead the jury in violation of Rule 401. Burden is not on the opponent to show why it is relevant. Or burden is on the opponent, sorry. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial value or effect, sorry. Evidence may be excluded if it confuses the issue. So basically, the same thing with regarding the same arguments for the geofencing, which is what I said. They could just say, well, it's too confusing. Geofence data, it's going to confuse the jurors. Unbelievable. All right, so any reference to any prior bad act or acts of any witnesses that plan to testify at the trial. Well, is this or is this not like what you're supposed to do is kind of like impeach your witnesses? And if bringing up those bad acts might be relevant and has something to do with that, you might want to be able to question them, to impeach them. But Nick McClellan says, no, that's not your right to do. You just leave our witnesses alone. So, any reference to any prior bad acts of any witnesses that plan to testify at the trial that is not relevant to what the defendant is on trial for, that is not on an act that is an exception to IRE 404B, and that is not both relevant under IRE 401 and tend to negate the guilt of the defendant. There's a whole mess of stuff there. 11, any references to how the files were labeled and were handed over to the defense. Oh, so the state wants to admit we gave you some really screwy discovery, the way that it was organized, labeled, and mishandled as we handed it over to you. So don't tell the jury about that. Don't tell on us to the juries, to the jurors is what this really says. So, any reference to how the files were labeled that were handed over to the defense as part of the information and discovery provided to defense counsel by the state that are not relevant or that would tend to cause confusion of the issues or has the potential to mislead the jury in violation of Rule 401, burden is on the opponent to show why it's relevant and same old arguments. Any reference to any PowerPoints provided by the state as executive briefs involving any person or persons that were investigated by law enforcement as part of the 6-year investigation into the homicides of Abigail Williams and Liberty German that are not relevant or would tend to cause confusion of the issues or has the potential to mislead the jury in violation of Rule 401. Burden is on the opponent to show why it is relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. Evidence may be excluded if it confuses the issues. Wherefore, the state of Indiana, by prosecuting attorney Nicholas C. McClelland, respectfully requests this court to grant the following relief. A. Order the defendant through his counsel and witnesses to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to any of the above matters without first obtaining permission of the court outside the presence of a hearing of the jury. So they can do kind of a voir dire of the witness during trial if they need to, but I have a feeling it's not going to go their way there either. So, because it's Judge Gull. And B, to further order said persons to make no reference to the fact that this motion has been filed and granted. So basically, don't tell them about any of this stuff that the state is doing, and don't tell them that we told them not to tell you about it. Oh, wow. He is a little whiny baby. That's what Nick McClelland is. All right, so we're going to read through the order now. This is, it just came out yesterday, September 4th. And it says, the court, having had the state's motion in limine under advisement following a hearing conducted on August 1st, so it still took her over a month to get this, and having heard and considered the evidence, admitted exhibits, arguments of counsel, defendant's supplemental submission regarding state's motion in limine, so all of the court documents regarding this uh, issue, grants paragraph 1 through 6. So she just granted paragraphs 1 through 6. So let's back up here. Let me zoom out and start at 1. So comments about counsel, any comment which constitutes personal opinion by the defense, any innuendo or inference that is not supported by admissible evidence, any attempt to indoctrinate the jury, any attempt during voir dire to have the jury prejudge the credibility of witnesses, and any hypothetical questions that includes facts that are not in evidence. So those are all granted over defendant's objection and grants paragraphs 8 through 12 over defendant's objection. So 7 is the only one that, what? As it relates to paragraph 7. Okay. Before we get there. So let's do paragraphs 8 through 12 real quick. So 7 is obviously the third party stuff. So 8's any reference to the investigation, any geofence data, info, any reference to prior bad acts of witnesses, any references of the mislabeled discovery, any PowerPoints that the state had in an executive brief. All of those things they cannot bring up at trial. So, again, debilitating them from putting on a defense. As it relates to paragraph 7, the burden is on the defendant to show a nexus between Odinism, cult or ritualistic KI double Ellings, Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Klein, Jerry Klein, Ron Logan, and the homicides of the 2 victims. The case the case law is quite clear that the nexus must not be based on speculation, conjecture, rumors, or hearsay, but rather on admissible evidence. The court finds the defense has failed to produce admissible evidence demonstrating a nexus between Odinism, cult, or ritualistic KILing and all those people and the victims. Therefore, the court grants paragraph 7 of the state's motion in limine over defendant's objection. The court will not permit the evidence submitted by the defense in support of their arguments regarding third-party perpetrators in the trial of this cause, as the probative value of such evidence is greatly outweighed by confusion of the issues. And its potential. I told you, it's that whole confusing the jury. You don't want to confuse the jury by talking about any of this stuff, so let's not bring it in. Basically, taking away Richard Allen's entire defense. She will allow it. All right, so makes me so angry. All right, so the court will not permit the evidence submitted by the defense in support of their arguments regarding the third party perpetrators in the trial of this cause, as the probative value of such evidence is greatly outweighed by confusion of the issues and its potential to mislead the jury. The court will allow that evidence to support an offer of proof. So, do a proffer, offer of proof where they um, can try to make the connection there without the jury present, but I don't think Gull's going to allow it a whole lot, or rule in their favor much. So the offer of proof, if one is made by counsel. Jury selection will commence in Allen Superior Court October 14th. So they are moving ahead next month, September, October, yeah. We're in to October, almost a month away, about 40 days away from trial. All right, so the trial commencing in the Carroll Circuit Court concluding November 15th. So there you have it. That is from Judge Gull, Francis. I can't stand the woman, Judge Gull. She's so biased. She's not going to let us see this trial either, which makes me think that there's more she's trying to hide. It's so shady. All of her actions just scream corrupt, scream cover up, scream something's wrong. And yet The Supreme Court allowed her to stay on twice. They denied the defense's motion to boot her off of this case. And I think those were huge mistakes. And Richard Allen's going to potentially get a new trial out of this, which I think he deserves. I don't think that you should be able to cut off a defendant from being able to defend themselves, no matter what their defense is. It could be the craziest thing. It could be moon men came to me in a dream and told me to end my mother, whatever. And then that's my defense. That's what that's what happened to me in my personal reality. I should be able to argue that. Like, I'm just saying, people have reasons or people have defenses that might not make sense to everybody. They might be perfectly sane to somebody else. Doesn't mean that you should cut them off and keep them from being able to defend themselves completely. So I disagree with many of Judge Gull's rulings. Well, you guys know where I stand with her. I just hope that after this calamity of a trial happens and he's going to be convicted. There's no doubt about it. She's letting all of the confessions come in and she's taking away every ability he has to defend himself. She has done everything possible to give the state a guilty, and that's on Gull. This is all on Gull. I blame her. I blame the prosecution for bringing it forward, for charging this man when there's zero evidence against him that we've seen, zero connection to the girls, other than he was there that day. How many people were there that day? We have geofencing that many people were there that day. And there's many issues with the phone data itself, the geofencing of Libby's phone, how it turned off and then turned back on again, apparently. So it's just, there's too many what ifs and questions, and for them not to be able to bring that doubt into trial, you're handicapping him completely. And I don't like it. It's not fair. And I don't know where you people are in Indiana. Why are you not standing up and protesting this woman? Because I would be if I lived there, for sure. I would be at the courthouse wanting to get her removed from the bench every day. Protest. You guys have a right to say who rules over your community and who makes the decisions. And when there's people like Judge Gull, who obviously are corrupt and aren't there for justice, you got to question it. You got to wonder what's going on. I think there's something way bigger, way more complex, and way more insidious going on in not just Delphi, but Carroll County and the surrounding areas with law enforcement and prosecutors, judges alike. There's something going on, a big connection between everybody covering stuff up. And I'm not saying like it's a huge conspiracy, everybody's in on it, but there's a lot of people in on it. I don't know. It's just there's too many questions, too much doubt, and again, they're not allowed to bring it in, which is awful. Just awful. What do you guys think about this ruling? Let me know what you think about Judge Gull. What do you think about all of it? What do you think of Richard Allen's chances of being acquitted? I think he has zero now. I thought he had maybe a 10% before. Nah, I think he's got about a 0% chance. Let me know what percent chance you think he has in the comments below, and I will see you guys in the next one. Thank you so much for watching. Take care, and please hit the like button on the way out. I'll see you guys. Bye.